Hey, Rachel, how are you?
Hi, Professor Harmon.
Give everybody a second to join up. Scott, you there?
I am, yes.
All right, let's find you real quick. There you are. Okay, there you go. Thank you, Scott, for zooming in. Looks like we got a good, healthy cohort here. So I think I'll start with the introductions, and hopefully people will continue to join as they will, but we'll be respectful of the time today because this is our first day of classes and I've got to get to school to teach a class too. So we'll keep things within the time that we have allotted. I'm A.G. Harmon of the Columbus School of Law at the Catholic University of America. And on behalf of the faculty, let me thank you all for zooming in to this first of our presentations in the Student Scholar Series this year. The series was instituted, I don't know, I think this is like about 13, 14 years ago. When we first instituted this thing, it's hard to believe that long, but it is meant to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. And today's presentation will be made by third year student Rachel Simoneau. So before I introduce Rachel, I'm going to say a few words about the respondent to her presentation. And as you all know, and anybody who's not attended one of these before, Rachel will make her presentation, then Scott Goldschmidt will come in and respond to her comments. They will have a 10-minute back and forth with questions. Her presentation is presented, and then we'll open it to the floor for questions. So as to Scott Goldschmidt, he is an attorney in the higher education practice at Thompson Coburn LLP. He frequently advises on discrimination law, student affairs, contract drafting and review, and policy development, and is well-versed in navigating all types of day-to-day and long-term legal demands facing colleges and universities. Scott also has experience with crisis management, advising on reputational concerns, and implementing controls to mitigate risk. Prior to joining Thompson Coburn, he was the Deputy General Counsel for Catholic University. He also worked as a law clerk for the U.S. Department of Education, Office of the General Counsel, and was a research assistant for the 5th edition of the Law of Higher Education by William Kaplan, who was a previous of our faculty, and Barbara Lee, and served as a City Year Corps member in a Washington, D.C. public school. He holds a BA in political science, magna cum laude from the George Washington University, and his JD from our school, the Catholic University of America, Columbus School of Law, where he was lead article editors on the Law Review, editor of the Law Review. So we thank him very much for taking time to come today to do this. It's an honor to have him. Now, as to our student scholar, Rachel Simoneau graduated from the Catholic University of America in 2018 with a BA in politics. She has interned for the League of United Latin American Citizens, clerked for administrative law judges at the EEOC's Washington field office, and interned for Catholic Charities. She plans on working in policy after law school and became interested in the issue of cross-examination on college campuses after hearing the personal stories of her friends and observing the national conversation surrounding the Me Too movement. So I'll turn the floor over now to Rachel to present her work entitled Cross-Examining Someone Who Says Me Too, the Effect of Haidak on University Due Process. Rachel.
Great, thank you. Let me just share my screen. And okay, great. Hi, everybody. Thank you for coming. My name is, as Professor Harmon said, my name is Rachel Simoneau, and I'm here today to present my research entitled Cross-Examining Someone Who Says Me Too, Effective Haidak on University Due Process. I would like to thank Mr. Goldschmidt for being my respondent today, and I would also like to extend thanks to Professor Drinan for being my expert reader and supporting me throughout this project. Before we get started, I just want to bring to your attention that today's presentation will discuss sexual assault You're welcome to leave today's presentation at any time if this is a sensitive topic for you. And with that, I'll begin. So cross-examination is considered to be one of the greatest truth-finding engines in criminal proceedings, but when used in university disciplinary hearings for cases that involve sexual misconduct, the benefits aren't as clear. As the modern Me Too movement started gaining national attention in late 2017, more and more survivors of sexual assault began coming forward and sharing their stories. As a result, more individuals also began to report their assaulters. This ripple effect could be seen on college campuses, with some college administrators reporting an influx of formal complaints in recent years. I personally know many women who have been victims of sexual assault. Some decided to report their assaulters and others did not. And as mentioned by Professor Harmon, hearing their stories and seeing this topic get national attention was what inspired me to conduct this research. Sexual assault on college campuses is an epidemic. A 2019 campus climate survey by the Association of American Universities found that 1 in 4 female undergraduates have reported experiencing non-consensual sexual conduct through physical force or incapacitation. 1 in 4. And this epidemic is getting worse. The same survey reported a 3% increase in non-consensual sexual conduct from 2015 to 2019. Under Title IX of the Education Amendments of 1972, universities that receive federal assistance must provide equal access to educational opportunities regardless of sex. This was expanded to include sexual harassment and violence. Colleges are required to investigate complaints of noncompliance and must also have grievance procedures in place. If a school violates Title IX, they're at risk of losing federal funds or even being subject to litigation. Interpretation of Title IX over the years has varied from administration to administration. Under President Obama, the Department of Education released a Dear Colleague letter in 2011, which discouraged schools from allowing party-conducted cross-examination. The department believed that such cross-examination could be traumatic or intimidating for the victim and would create a hostile environment on college campuses. This letter, however, was then rescinded by the Trump administration in 2017. And the Department of Education then underwent proposing and finalizing a new Title IX regulation. While I was undertaking this research project, this rule had yet to be finalized. But as you can see from this timeline, the note and comment period closed in February of 2019, and the final rule was published in May of 2020. Universities had to change their procedures to adopt the regulations for this current school year. This final rule requires schools to permit party advisors to cross-examine parties and witnesses directly, orally, and in real time during a live hearing. Parties can obtain their own advisor, which can be a lawyer, but if a student does not obtain their own advisor, then the university is required to provide one for them at no cost to conduct the cross-examination. If an individual fails to submit themselves to cross-examination, then the decision maker cannot rely on a statement by that person. The final rule does include some provisions such as screening questions for relevance before allowing someone to answer, allowing upon request that parties be in separate rooms with audiovisual technology, and a rape shield evidentiary protection. But ultimately, this final rule requires universities to include the opportunity for cross-examination by party advisors in their grievance procedures. However, prior to this final rule, schools were working under the Obama administration's guidance, which, while discouraging party-conducted cross-examination, gave universities the flexibility and discretion to decide whether or not to include cross-examination in their grievance procedures. This resulted in some universities having cross-examination conducted by parties, by advisors, or not having cross-examination available at all. During this pre-final rule era, some interesting due process case law emerged. Some accused students, after participating in a university disciplinary hearing, filed actions against their schools in federal court on several grounds, one of which being a violation of their constitutional due process rights because they were not afforded the opportunity to cross-examine their accuser, and a circuit split emerged. Before we delve into the federal circuit court cases, there's some pertinent Supreme Court case law that I want to provide to you as background. So historically, the Supreme Court has imposed minimal due process requirements on educational institutions. You do not have a federal right to an education under the Constitution, but the US Supreme Court in Goss v. Lopez held that state law can create a right to an education, and once created, public universities cannot deprive a student of that right without due process of law. However, the Goss court also held that the due process clause does not require hearings connected to short suspensions to have cross-examination. The court acknowledged that cross-examination may increase formality, burden schools administratively or financially, and make parties more adversarial. However, if greater punishments are available, the court acknowledged that more formal procedures may be necessary. Due process requirements are not the same for criminal and administrative proceedings, which includes educational grievance procedures. The Matthews v. Eldridge Supreme Court case set out a list of factors to determine whether an administrative proceeding comports with due process. So these factors include the private interest, the risk of erroneous deprivation of the protected interest, and the probable value of the additional procedures, and also the government's interest, which can include financial or administrative burdens. These factors will be used in the cases discussed today. So there are several buckets that the federal circuits have placed themselves in when deciding where they fall on the issue of cross-examination in university hearings. Some circuits have yet to pick a side on this issue due to either the facts of the cases before them or not needing the question to be answered due to deficiencies in the pleadings and for other reasons like that. But the main disagreeing circuits include the Sixth and the First Circuits. So in 2018, the Sixth Circuit ruled in Doe v. Baum, which involved a student who filed a lawsuit against the University of Michigan, claiming that the university's disciplinary proceedings violated the due process clause because the decision turned on a credibility finding without providing a hearing with an opportunity to cross-examine his accuser and witnesses. The Sixth Circuit found that cross-examination has many benefits, including identifying inconsistencies in testimony and also evaluating the demeanor of witnesses. However, the court found that the accused students' interests, which include being forced to withdraw from school, negative impact on relationships, and roadblocks in the future, outweighed any what they deemed to be minimal burden on the universities to include cross-examination. Therefore, in the Sixth Circuit, if a case boils down to competing narratives, then cross-examination must be available. However, the Sixth Circuit did acknowledge that the party does not have a right to personally conduct cross-examination, and alternatively could be conducted by an agent aligned with the student. Conversely, the First Circuit has placed itself at odds with the Sixth. So in Haidak versus University of Massachusetts at Amherst, a student had a physical altercation with his girlfriend. A no contact order was issued by the university, which the student later violated. He was then suspended. The University of Massachusetts at Amherst had proceedings that allowed for students to submit proposed questions beforehand for the hearing board to consider, and then the hearing board itself would then ask those questions. The student in Haidak submitted 36 questions, and the assistant dean of students rejected 20 of those questions before passing along the remaining to the board. And while the board did not ask exactly the 16 submitted questions, it asked similar questions to elicit the same information. The accused student and the complainant were examined 3 times in an alternating manner. As a result of this hearing, the accused student was found responsible for charges of assault and failure to comply and was therefore expelled. And then the university upheld this decision upon appeal. The expelled student then filed suit in federal court on several grounds, one of which alleging a due process violation. The district court for the District of Massachusetts granted the university's summary judgment motion, which the student then appealed. This case then came before the US Court of Appeals for the First Circuit, and the First Circuit refused to adopt Baum's rule that cross-examination by either party or representative is necessary when credibility is at issue. The Haidak court recognized similar interests as the court in Baum. The accused student has an interest in pursuing higher education, avoiding unfair exclusion, and escaping the associated stigma with being disciplined. On the other hand, universities have an interest in protecting the institution and its students against unlawful behavior. Universities also have an interest in allocating their resources and maintaining decorum in proceedings. And ultimately, the Haidak court found that the university's concern about devolving decorum outweighs any probative value that the cross-examination would provide. So the court refused to find that questioning by a neutral party would be so fundamentally flawed as to categorically create a risk of erroneous deprivation. The court also emphasized that if it were to create a right to party-conducted cross-examination, this would be a slippery slope to the participation of counsel and would create a mandated mimicry of a jury-waived trial. If a university does not allow for direct cross-examination, it still has to fulfill its responsibility to conduct a reasonably adequate questioning. The First Circuit Court found that it was a close question in this case whether the university had fulfilled this responsibility. But because the board questioned the students by asking for more details and clarification in an alternating manner, it had provided adequate due process in the eyes of the First Circuit. It therefore affirmed the district court's dismissal of the students' due process claims. And I believe that this holding in the Haidak case is the appropriate one. As acknowledged by various courts, being suspended or expelled due to a claim of sexual assault can have an impact on men. But the interests of the alleged victims should also not be ignored. We need to protect victims and encourage reporting of sexual assault on college campuses. While the stigma of being labeled a sexual offender can have lasting impacts on future opportunities and relationships for men, there are also lasting impacts on women. Notwithstanding the emotional and physical trauma of being assaulted, reporting itself can be re-traumatizing. If women know that they'll be cross-examined, they may choose not to come forward and report what happened to them in order to avoid further trauma. According to a former US Department of Education attorney, 88% of sexual assaults against undergraduate women are not reported. And in 2016, 89% of universities disclosed 0 instances of rape. If we truly want to combat sexual violence on college campuses and protect the 1 in 4 women that are affected, then we need to first have accountability for these perpetrators. And the only way we are going to get that accountability is if women feel comfortable reporting what happened to them. An adversarial grievance process with cross-examination being added in the name of due process will only make that process more emotionally burdensome for these victims. Unfortunately, we've seen this issue become highly partisan and politicized coming out of the Me Too movement. We have seen politicians such as former President Trump claim that it is a scary time in America for young men. And proponents of cross-examination have alleged that this due process is necessary because of the risk of false allegations and how a false allegation can ruin a man's life. A Morning Consult survey found that 57% of US adults are equally concerned about women facing sexual assault and young men facing false allegations. However, this concern is not based in reality. According to the executive director of the organization End Rape on Campus, only 2 to 8% of all sexual assaults or rapes, and that's in the criminal context too, are falsely reported. When unreported assaults or rapes are taken into consideration, that rate of false allegations is approximately 0.002 to 0.008%. False allegations do happen, and when they happen, it's reprehensible, but they're rare. And the Me Too movement has a Believe Women rallying cry, and critics fear that this narrative means that women will be believed unequivocally without question during these proceedings. But this is not the case. It's possible to have fair proceedings in a university setting, like stated by the Haidak court, that one can determine the truth and flesh out these rare false allegations without needing cross-examination. The benefit of cross-examination in these proceedings does not outweigh the risks to victims. And in a university setting, a proceeding without cross-examination should be preferred in order to combat this highly unreported epidemic. Also, universities are not courts. We should not expect universities to uphold themselves to the same standards and procedures of common law trials. Universities have administrative concerns such as efficiency and finances, and expansive due process requirements are expensive and time consuming. And nor is this the expertise of educational institutions. They're not judges. Universities have to balance the obligation to serve both the accused student and the complainant during proceedings while maintaining a safe environment for their campus community. Universities should not be expected to become quasi-criminal justice systems when they're just not adequately equipped to do so. And so therefore, the Department of Education's final rule should be revised to remove the required permission of advisor-led cross-examination. As communicated by the Haidak court, an absence of cross-examination should not categorically be a due process violation. And such a requirement should not be added to our regulations in the name of due process. Universities should want to advocate for this change, as it will not only cut their administrative costs, which will then in turn make it easier for them to uphold their Title IX responsibilities, but it will also encourage victims to come forward by adopting less adversarial procedures. The conversation regarding our country's sexual assault epidemic will continue to develop in the courts, on campuses, and in our country. And in the end, we should not be making it harder, such as requiring cross-examination for 1 in 4 women on college campuses to come forward and say, "Me too." Thank you, and I'd like to turn the floor back to Professor Harmon.
Thank you, Rachel, very much. Now I'll turn the floor over myself to Scott Goldschmidt to conduct the response.
Perfect. Thanks, Professor Harmon, and thank you, Rachel. That was a very detailed, well-done presentation, and you're really grappling with the main issues that are going to be with us for a long time. So I'm happy to be here, and I'm happy to kind of get a chance to talk to you about it. First question to you, I wanted to kind of talk about the final rule that you mentioned. The Trump administration's rule in effect as of August, in 500 pages of preamble, wrestles with Goss and Matthews and Baum and Haidak, and comes to the conclusion that cross-examination is necessary as part of a fair truth-seeking grievance process, as you mentioned, but also devotes a ton of time to some of the safeguards to minimize traumatic effects, such as having cross-examination occur in separate rooms, having cross-examination kind of never conducted by a party personally, relevancy requirements, rules of decorum for institutions, and rape shield protections. So I just wanted to get your comments on the way that the administration kind of balanced those issues, and kind of any thoughts specifically in mind with the safeguards that were put in place by the administration.
Great. Yeah. So as you mentioned, the Department of Education has recognized that re-traumatization is at risk in these proceedings, and it's attempted to mitigate that risk by adding some of the safeguards that you mentioned in order to protect victims during these proceedings. But I don't believe, and survivor advocates agree, that these are sufficient to protect against re-traumatization. So like, for example, of course, while being cross-examined by one's rapist directly would be particularly traumatizing, having the cross-examination conducted by advisors instead does not substantially mitigate that risk. Cross-examination as like a process itself has been found to be traumatic. In adversarial proceedings, like victims can be intimidated or embarrassed during cross-examination. And as we see in this rule, students have the ability to select their own advisor. And so these advisors can be lawyers. And so lawyers, especially defense attorneys, can sort of more lean towards victim blaming. And especially if they're like zealous advocates, this risk is only higher. And so I think just because while it's great that these provisions are in place, and just because we acknowledge that, the students themselves should not be conducting this cross-examination, which I do believe is correct, I don't think just mitigating that risk through advisors is going to, substantially mitigate the risk of re-traumatization by victims. And then you mentioned some other safeguards, such as like screening for relevance and establishing rules of decorum. And while those are great, and I'm glad they're there than not being there in this final rule, as I mentioned, like, this isn't the area of expertise for universities. And so unlike in a courtroom, which is presided over by a judge who has years of experience on evidentiary rules and relevance and what should be admissible, not admissible, these are universities. And so now universities have to grapple with training these advisors and training their hearing officers and ensuring that they can sort of get as close as they can get to that, like in becoming quasi sort of criminal justice systems. But I think that's just like, I think it's unrealistic that we're going to get sort of this mimicry of courts within universities, and we shouldn't want to either. So I think that's a great question you ask. And while I do think all these safeguards in the final rule are important, and I'm glad they're there than not, I don't think that they completely solve the issue, which is why I think we should just not require cross-examination at all.
Let me try and pin you down on the breadth of your argument. So I understand your point about re-traumatization. Are you concerned, kind of putting that aside, the accused student by not having cross-examination as an option? Is that potentially infringing on their rights as a student that kind of has the right to an education and all the other pieces you spoke about?
Right. So I don't want to come off as saying that like I don't recognize that like we also need to protect accused students. Like, it's very important that accused students are able to share their side of the story and be able to know the allegations that they're facing. And I think there's a way to do that without inherently requiring cross-examination. So like, for example, like the final rule could, if we got rid of the requirement for cross-examination, the final rule could say that, at minimum, we need to require a live hearing with, parties need to be able to submit questions beforehand to the fact finder, and the decision maker has to then, after like levels of screening, ask those questions on their behalf. And then like, if the questions are asked, like in the Haidak court case, that fact pattern, the questions were asked in an alternating manner. And what alternating questions provide is an opportunity for a party to respond to what was just said by the other parties. So while it's not sort of a direct questioning or questioning by their advisor directly to the other party, if I ask a question to this student and then I ask another question to the other student, that student heard what the first student said. So if there was something about that they can address in their statements or in that question, that provides like opportunity to respond outside of sort of like the questioning model. So I think like adding protections like that, and like having like screening and submission, and like possibly requiring like opening statements and closing statements and stuff like that, I think that provides accused students opportunities to share their side and to present evidence, and to like properly present their side of the case without having to work within a cross-examination model. And I don't think that's inherently unfair or against due process, just like the First Circuit decided.
Let me follow up on that. The Biden administration's made no secret of the fact that they want to get rid of these regulations as fast as possible. And while it may take some time, they're in the works, I'm sure, trying to rescind these regulations. If you were advising the administration, I think specifically with regard to the protecting the accused rights, because I think we talked about potential victims here, what pieces of the rule would you put in place with regard to questioning to make sure that everyone's rights are protected and that they can can get their case out adequately.
Yeah, great. So if I were to advise the Biden administration, similar to what I just said, like I would, first of all, remove the requirement of cross-examination by advisors. And then this would allow jurisdictions that don't have binding case law, like the Sixth Circuit does with the bomb case, to have less adversarial proceedings. And so I'd remove that. I would keep the part of the rule that prohibits parties from directly cross-examining both witnesses and parties. And then, as I mentioned, we can like set minimal requirements, such as if universities aren't providing for the opportunity of cross-examination, they should like at minimum provide a live hearing with an opportunity for students to submit questions that are then screened for either relevance or to ensure they're not, I guess, like overly burdensome or intimidating, or like the frame of the question or tone of the question doesn't sort of break with rules of decorum. And then I also don't think universities should necessarily be pinned down to and required to ask all of the proposed questions. I know in the Haidak case, it was a close question because, you know, the dean of students had struck in some of the questions before it even got to the hearing board. And like, you know, that's a fine line there, but I don't think there should be like a bright line rule that like all proposed questions should be asked, as long as they, like the Haidak court said, like as long as there's like a reasonable, adequate questioning and inquiry into the truth. Like I think we should leave that more broad so universities don't have to feel as, I guess, like burdened by that requirement. And then, like I said, like requiring questions to be asked by like the neutral party in an alternating manner, having opening and closing statements, and like requiring like that the university should ask follow-up questions for clarification, like when appropriate. And there are other ways to protect due process as well. So, you know, this wasn't the subject of the presentation, but like we can make sure they're given written notice of their allegations and like a copy of the investigative report, which are in the current rule. So I think all those provisions of the final rule are great. And I think we can, you know, take bits and pieces from the final rule and then lower other requirements, and it can still present a rule that can both, you know, take in interests of victims and then also accuse students as well. And I think there's a middle ground there that the Biden administration could implement.
Your proposal, and this very well may be the tack taken by the administration, would have different procedural requirements kind of based on the circuit the court is, and public and private. And so students, depending on their the nature of their school and location, may have more or less protection. Does that concern you?
Yeah, so the private and public distinction doesn't concern me as much. So I didn't talk about this in my presentation as much, but just a little bit of background for the audience is that, so currently any school that receives federal assistance must comply with Title IX. So private institutions have to comply with Title IX if their students even receive like federal loans or grants or scholarships, which can count as federal assistance. So private institutions are still, you know, generally speaking, bound by Title IX. And so, but outside of the Title IX world, when we look to due process, private institutions aren't so-called like arms of the state like public institutions are. And so they're not subject to the Constitution's due process guarantees. So if a private institution does not need to provide for cross-examination according to its jurisdiction's interpretation of due process, it would still be required to under the current final rule under Title IX requirements. And like I said, I don't think the public versus private distinction is as problematic because, at least from my experience, I think students understand, at least in general terms, that they're getting a different experience when they attend private institutions and public institutions. And I think, you know, whether or not they're aware of it, that distinction doesn't bother me as much. I understand, but to your second point of jurisdictional differences, I do think that is problematic because I think we expect the Constitution to apply uniformly to Americans, no matter, you know, what region or state or jurisdiction that they're in. So I do think that this emerging circuit split is concerning, but I don't think that, like on the other hand of the argument, I don't think that we should be afraid of creating the circuit split, because if, judges in these circuits do disagree with sister circuits on how they ruled on due process, then they shouldn't be afraid to create a circuit split just because of the repercussions in distinguishing, having students have different due process rights in their jurisdiction than other jurisdictions. I think that almost, it creates the opportunity for the Supreme Court to then come in and, correct this distinguishes and, make a final determination on this issue that would apply uniformly across the country. So I don't think we should necessarily be afraid of that, because it does down the line make it more likely to be resolved. But also, I would just say that I think students need to start, because this is such an epidemic, I think students during the admissions process need to start also researching into Title IX and looking at the universities that they're applying to's procedures and what the rules in their jurisdiction would be if they attended that school. And, this isn't something that you normally think about when you're going through the admissions process, but I think that's something that we should start considering as students, because if this is something that is a shared experience of 1 in 4 female undergraduates, then both potential, respondents or complainants would need to know what that process is going to look like if they go to this university in this jurisdiction. So I think that's just another thing to consider from a student's perspective.
Yeah. Does the fact that this rule is in place right now, this final rule, does that kind of preempt any action by the Supreme Court? Is there still an issue for the Supreme Court to decide right now, or would they have to wait until the Biden administration or someone rescinds that rule?
I think it's more likely that they would wait. I don't think it inherently preempts Supreme Court review, but so just as an explanation, the regulations set a procedural floor, but they cannot impose a roof that does not comply with constitutional due process. So the constitutional question still remains unresolved because of this circuit court split. But as you mentioned, as of now, under the current Title IX final rule, universities will be required to use cross-examination. So therefore, it's unlikely that new cases will emerge on this narrow issue moving forward, as the students bringing these claims in federal court would have presumably been provided the opportunity for cross-examination. I could see, of course, a student could argue that he has a right to personally cross-examine parties or witnesses, and then therefore the rule would, and the university procedures would violate the due process rights of him for that reason, but no jurisdiction has found such a right to exist. So I find that unlikely. But additionally, these rules don't apply retroactively. So there may still be some lawsuits or hearings regarding hearings or incidents that occurred pre-final rule that could create more case law on this issue, even if it doesn't, it wouldn't lower any due process requirements of universities, because they would already be complying under Title IX. So as of now, the Supreme Court review isn't necessary because of the final rule, but as we just mentioned, if the Biden, depending on what the Biden administration does, what their sort of guidance or revisions moving forward are, then more circuits may rule on this issue, which could potentially strengthen the circuit split. And in that case, the Supreme Court likely would and should act on the issue. And, I believe that they should agree with the First Circuit and Haidak.
Let me ask this. One of the preamble kind of points that the Trump administration relied on to kind of show cross-examination as the appropriate thing is that these hearings, when you have a he said, she said sexual assault dispute, are inherently adversarial. And then adversarial hearings, due process or cross-examination is, as you said, one of the great ways to kind of get to the truth. Do you think that Title IX hearings are inherently adversarial, or do you have a different view?
I wouldn't go as far as say they're inherently. I would say they're mostly, in most of the cases, they're going to be inherently adversarial. I think there's a difference between being emotionally, there's a difference between adversarial and like emotionally burdensome or challenging and stuff like that. Like an adversarial nature inherently like pits people against each other, and like that's going to be the case no matter what. But like from a pure credibility standpoint, like when I was doing case research in some of the circuits that have yet to rule on this issue, they have declined to do so because of the facts of the case. So in one case, students made similar arguments as like the students in Baum and Haidak, but there was like video evidence of the incident, and the students didn't question the legitimacy and authenticity of those videos. So the court found that they didn't have to rule on like cross-examination wasn't necessary because it wasn't based on necessarily, it didn't boil down to credibility and like these he said, she said situations, because in that case, there was evidence that they didn't dispute. So therefore, like cross-examination was necessary because it was almost like, I guess, admitted at that point. And so I think like, but that's not always the case. There's not always going to be fact patterns that line up with they. So I wouldn't say like they're inherently adversarial, but I would say that most of the time they are, because most sexual assault situations are he said, she said. And even when there are witnesses, like in the Baum case, there were, I think, over 20 witnesses, but most of the female witnesses agreed with the complainant side of facts, and most of the male witnesses agreed with the respondent side of the facts. So even amongst the witnesses, it can still become he said, she said. And, like, I wouldn't say generally universally they're inherently adversarial, but I would say from a credibility standpoint, most of the time they are.
Okay. Professor Harmon, I'm happy to ask as many questions as I can. I don't want to monopolize the time.
Oh, you're muted.
No, I'm muted. Thank you so much. I guess, Scott, this has been very interesting, and thank you so much for conducting the response, and Rachel for responding so in such a prepared way. I will, though, I guess in the interest of time, just I'll turn the floor over to anyone that would like to pose a question, and if we have any, let's entertain those, and then we can return to Scott maybe with another finishing question. Anybody would like to hop in? I see Katie. I think Katie, if you'll just unmute yourself, that might be the easiest thing, and ask your question.
Hi, excuse me. Good afternoon, Rachel. That was excellent. I really appreciated your thoughtfulness in this presentation. And Scott, it's always good to see you. We've missed you, and it's great to have you back. My question, Rachel, and you may not have really considered this, but I'm curious. The new Title IX rules limited Title IX's jurisdiction, making it so that colleges are not responsible for off-campus incidents. I'm curious if in your research on cross-examination of complainants, you formed an opinion as to whether the scope should be expanded as it was under the Dear Colleague letter.
Yeah, so like you said, my presentation did narrowly focus on cross-examination, but I did see these other, in my research, I did come across all these other problems that critics have with the final rule, and one of which was the narrowing of the definition of sexual harassment to not include off-campus sort of incidents. And, it's from, due to my minimal sort of investigating into this issue as sort of like a corollary issue to my presentation, I came to the conclusion that I think that's an incorrect sort of regulation. I think we should expand the scope in order to cover off-campus sort of incidents, because I feel that it's when it involves when this involves a student or faculty member or whoever off campus that is a member of the campus community, then it should still be the university's responsibility to, I guess, like internally police the members of their community, whether or not those instances occur on their campus or off their campus, if it's amongst members of their community. And I feel like that really narrows what the number of incidents that are going to be reported to universities, because, there's students that live off campus. There are people who go to, parties or restaurants or bars or whatever. And I think if we limit it to incidents that occur on campus, then that's just going to even further narrow who or what type of incidences or the number of victims that will come forward to report. And so I think we should be, we shouldn't go overboard with the scope of this. We should still definitely keep it relevant and keep it relatively narrow. But I think we should broaden it beyond the final rule to include these incidences, because like I said, if 88% of the sexual assaults against female undergraduates, which is 1 in 4 female undergraduates, are not reported, then I don't think we should be narrowing what types of these incidents can be reported if we're trying to sort of combat this epidemic.
Any other questions? Rachel and Scott, let me just ask you something rather innocently. I'm a little confused about here. But how would this work if you're the accused, and so under Rachel, as you proposed this idea, the accused would present a series of questions. Would the questions go through then an editing process before they are put to the accuser? And if so, what, and Scott, you can hop in too, either one of you answer this. What protects the accused from saying, oh, but they're going to change my questions, or they're going to edit my questions, they're not in court, they may not present, I can't cross-examine, and I can't even be sure that my questions are put as I posed them. What's the control over that kind of thing?
Scott, did you want to talk about the current sort of relevance requirements that are in the final rule, or did you want me to jump in?
You jump in. Yeah, I'm happy to jump in after, but please.
Okay. So, I think that's an interesting question, Professor Harmon. I think that like I said, like in the Haidak case specifically, they said it was a close question because it had undergone such a, not so much editing process, but like just questions themselves were stricken. But I think what could be put in place is that if sort of decisions are made on the questions themselves or regarding relevance, or if they're, I guess, like tweaked by this sort of reviewing process, then they could, the university, currently under the final rule, universities on relevance determinations have to provide a reason for why they deemed a certain question to be unrelevant. So I think under my proposal, a similar sort of requirement could be there for a university to explain why a question was either struck or why it was tweaked if it was, against the rules of decorum of the university, of whether it was toned as like too aggressive or was about information that was covered under, like we said, like rape shield protections and stuff like that. Like the university can provide an answer for why, and then possibly we could have like the university could implement like I guess like if this is occurring prior, if these questions are proposed prior to the hearing and these decisions, if the student is informed prior to the hearing on those decisions, then we could have a sort of, I guess, like minimal review process set in place where a student could like challenge it. If they're given a reason why, then the student might be like, okay, I get why that question was struck, or could propose additional questions to, I guess, replace that if they felt that a certain topic wasn't being brought up. But I think I'd be interested to hear what Scott has to say, like how the final rule works with relevance, because I know there's a lot of critiques right now that it's sort of unclear how these sort of relevance standards are put in place, and a lot of universities are struggling with that. So I'd love to hear his perspective from the final rules formulation.
Yeah, no, sure, happy to. Yeah, and it's a great question, and it's one that we've been training lots of universities on. Relevance is a requirement that all the adjudicators need to be trained on. It's not, as Rachel said, it's not up to the adjudicators to look at a question and say, I wouldn't ask it, therefore I'm not going to. The question is it relevant or is it not? And so if it's not, you have to provide a reason, and the reason doesn't have to be complex. It could be that it's a rape shield violation, or it's just totally out of bounds, or that kind of thing. But that's the safeguard put in place, and to make sure that the toothpaste isn't out of the tube before a person answers. The hearing chair needs to make a determination about relevance on every question asked. So they have to say yes or no, which is another kind of, as Rachel was explaining, tough for someone not legally trained to make that kind of determination in real time. But it is at least part of the safeguards that the administration was foreseeing as they were grappling with this question.
I see. Well, we're close to the end. Would anybody else? Laura, you had a question. Professor Lewis?
Yes, Rachel, thank you very much for a wonderful presentation, and also Scott for your very engaging discussion. One question I had, Rachel, is whether you had researched sexual assaults by women on campus. And if so, have the percentages been evaluated in terms of the numbers of persons who report and the numbers of persons who falsely report? Do those percentages differ from when the victims are, or rather the perpetrators are male?
Yeah, so I did do a little bit of cursory research. I don't have the exact statistics on hand, but at the beginning of my research, I noted that, well, during my project, I noted that while primarily most victims of sexual assault are women, obviously women can still be perpetrators of sexual assault, and just as similarly, men can also be victims of sexual assault. The not issue, but I'd say the reason why this issue sort of gets highly politicized, especially coming out of the Me Too movement, is because primarily, like I said, I don't have the exact numbers, but primarily women constitute the majority of the victims, and men constitute the majority of the perpetrators. So there have been studies that show that men are even less likely to report than women because of their increased sort of embarrassment, or they feel even stronger stigma than even women do to report. So that's also a cursory issue. My project primarily looked at it from the framework of women victims, just because that is the reality that is so sweeping across this nation. It's 1 in 4 women. It's a smaller statistic for men that experience sexual assault as undergraduates, but they definitely do exist. And I think that's something that should definitely always be considered within the framework. I know my pronouns throughout this presentation sort of was working with the assumption of, using she for victims and he for accused, just because that is the majority of, the situations that happen on campuses. But I think if we increase the conversation about, reaching how to reach out to men who are victims, and how to sort of destigmatize, men being victims, and also normalizing the idea that women can also be perpetrators, that can also, reach out to, this subset of victims that are even more so not being talked about by society. But I think the reason why that, like I said, the reason why this issue gets so politicized and so inflamed in, culture and politics and in the legal field is because it's often pitted as a gender issue. And, and while that's not the case, like we said, anyone can be a victim, anyone can be a perpetrator, the statistics show that it primarily happens to women and it's primarily conducted by men. So that's the reason why it's framed this way. So I think it's definitely interesting research, and it's definitely something that we should, look into more. But like I said, the reality of the situation just sort of naturally sways this conversation to be, gender focused.
Thank you, Rachel.
Well, good to our word, we'll close now. If this were a normal world, normal times, we would be having lunch and finishing up that, and we would have more questions out in the hall, and we would present an award to Rachel, and we are going to do that. We are ordering a plaque, and it is on its way to you. So we will do that even in these times. So thank you, Rachel, for a wonderful presentation to start off our series. Thank you, Scott Goldschmidt, our alumni, for doing this yeoman's work to participate in what we think is a very worthy program. And we will return again next month, but this is a great way to start it off. So thank you, Rachel. Thank you, Scott. Thank you all for coming.
Thank you.
Bye-bye.
Thank you for having me. Great job, Rachel.